Okay, if I could go ahead, everybody who wants to participate with the cadet presentations. I know many of you, or many of us will be off getting lunch and they'll probably trickle back in. But our first cadet presentation will be from Cadet Third Class, Ruben Banks. Ruben grew up in Jackson, Mississippi and is a legal studies major. And so I will turn it over to him for the first of our 3 cadet presentations.
Great afternoon. I'm elated to be here. But before I present to you this great idea that's on this board, the reasons why we need a Space United Nations, I want to start off with a little brief background of how I got into this subject. So C33C Banks decided to get involved in this organization called I-5 here at the United States Air Force Academy. Now, what exactly is I-5? I-5 is an organization that answers the unknowns of space, everything from policy oriented to anything engineering aspect. So when I was entering this organization, I really tried to understand what kind of impact could I have in a room full of nothing but aeronautical and astronautical engineers. And then funny enough, they made me a team lead of a project where I had no clue what I was doing. Fast forward, looking at it now being a team lead, I had an idea to sit down and introduce several members of the team with various backgrounds and understand the true need of space policy. So hence the reasons why we need a United Space Nation. So the United Space Nation is a mock research program that was started here at the Academy under the space policy team under the research delta of I-5. Now, something I want to point out within this organization is it is in charge of supplementing and redeveloping the current policies that the United Nations has in place concerning law. So as a legal studies major, we talk about everything as defining litigation. So what exactly does supplementing and redeveloping law looks like in terms of space? That is a great question, and that is what we're trying to answer. So the biggest definition that I found is pointing out to the idea that because there is no policy or certain litigation surrounding space, that the presence in space in itself is a question that must be answered. It has already been established, but going back to the drawing board, have we set anything forth in order to make sure we're establishing this space and this dominance in space correctly? So we've broken down this idea of the United Space Nation into 5 areas. The first being militarization, the second being space policies, the third being the regulation of commercial entities, the fourth being the regulation of space, regulation of the space of body, and the fifth being regulation of space vehicles. It's a lot of regulations. Now, the first one is militarization, which is the reason why majority of us are all here today. How do we effectively make sure that there is peace in space? As of right now, on the certain articles, there is only allowed, basically anything is allowed in space as long as it does not have any nuclear capabilities or weapons of mass destruction. But that calls into question conventional kinetic warfare. How do we solve this need that maybe one day there will be a conflict in space? How do we deter this conflict? So the idea of the United Space Nation is to make sure that we impose certain regulations, certain ideas, certain norms, which I hate to say, that in order to keep space safe and a domain and access for everyone to be able to use. Now, the second is space policies. This is kind of ironic. It's a space policy group, so of course we have to make more space policies. But this is what I consider my protege and actually the foundation of the group. I consider this also the factory of policies. As of now, because there are rarely any policies surrounding space, there needs to be some organization capable of producing policies for the near future. Majority of these define militaristic offensive capabilities. Majority of these define commercial entities within space. Some of these also define the types of space vehicles, something that we'll get into more so today. But the overall idea is space policy is the #1 need that we need now. We don't need more satellites, more rockets. We have enough. Well, astronautical engineers may not agree, but right now, with nothing governing the idea behind them, it is a free-for-all. So that goes into some of the biggest topics that we see nowadays is the regulation of commercial entities. Majority of general counsels in here represent some of these private sectors, and they'll hate to say that we need some norms surrounding this idea of how we interact in space. The biggest problem as of now is that every state is responsible for any non-governmental organization that is within space. However, coming from the US military, it's hard to say that the US government will continue to allow commercial entities to operate within their domain and they take responsibility for it, especially when these private sectors turn from just exploring to actually focusing on maybe deciding that the Mars land space is theirs, or maybe deciding that mining is an optional thing to do in space. Some of these are big things that are concerned that the Outer Space Treaty does not allow our state, the US government, in order to do. However, it never answers the question to the regulation of these commercial entities, which calls in a big question. Now, the next thing is the regulation of bodies within space. Now, the regulation of bodies within space takes control about this idea that space is limited, even though it's space. There is enough universe that you think that you'll be able to park a spaceship and just get away with anything, but hence is not the case. Now, majority of countries are taking a militaristic aspect in order to limit other countries' space. Hence, Russia and China recently blowing up satellites in order to shrink the amount of actual low orbital space that we have. This poses a problem. Now, the main concern of the United States nation is the idea that as of now, no state can own any type of space within space. How we deem this may soon change. The idea of just allowing an entity just to be in space with no repercussions allows someone to either take advantage of the opportunity and not offer it to others, or destroy someone's opportunity altogether, as we can see with other adversaries. So the biggest thing is, how do we monitor who's in space at what time is in space, and whether or not this should be something you pay for, or it should be something that's regulated amongst the population or size of your country? That is the biggest question we have. Now, the last thing that we kind of touch on is the idea of space vehicles. As of now, compared to what we saw 50 years ago, space exploration looks totally different. The European Union recently released a satellite with the capability of having a grappling call. Now, something as a legal studies major that we commonly look at is defining certain litigation in terms of words. One being, most importantly in space language, is weapons. What is deemed a weapon in space? Now, the biggest concern that the United States nation's team has is anything can really be a weapon in space, even a space vehicle. Even if it does not have the capabilities of producing any kinetic warfare capability, it can still be deemed a weapon. Whether it has a claw, whether it has some type of frequency jamming, whether or not it's a titanium rod from God that's able to be released and launched down to Earth, these are all concerns. And with no one regulating the actual uses or capability of space vehicles, this poses a big question into the idea of who actually has weapons in space as we speak, which is a main concern of everyone in their own entity of what they have in space now. So what is the overall goal of the United States nation's team? Now, keep in mind that I've only given you 5 areas of interest that we have now, but these are the most important, not the only interest. Now, the idea that I can give you is there are many members of my team with various backgrounds. So the idea that I have one team member, John, who's actually here somewhere in the back, he's an aero major. So the idea becomes that because I'm a legal studies major, I don't understand anything about aeronautical engineering except what John tells me. So this idea of formatting some type of way to make a FAA, which regulates space, may be an asset. This will come out of this United States nation's team. Now, the next group member that I have, Daniel, who's an astro major. Again, I don't know astronautical engineering. He understands rocket propulsion, not only how rocket propulsion affects the environment here on Earth, but how satellite pollution is a big concern and growing. In fact, I read an article 2 days on it by CNN. That's how big of a concern it is. And then you have other members who are looking at the economic impact. Michael, how do commercial entities actually determine what is in fact theirs? Whether or not states, territories have rights in order to claim what commercial entities mine, what they produce, and are they okay with it? And we have various things from political science, system engineering, and legal studies majors who are looking at the policy work and the systems behind developing policy surrounding engineering in space. So again, this is just a small, minute detail of things that we have that are afforded. And now I'll take any questions.
Ruben, thank you so much for your presentation. Wonderful job. Quick question with respect to just sort of legal development. The United Space Nations project that you and your team are working on, what would be your recommendations for the further development of rules or laws to regulate state space activity?
That is actually a great question. In fact, I was talking to one of my team members earlier today as we listened to one of the presentations. Now, the biggest thing in life is the private sector will tell you we don't want norms in space. We want it a free-for-all. But the idea is that in order to stop a conflict from happening, I think is now more than ever a concern that we produce litigation up front in order to keep certain things from happening on the back end. Space is a domain where we can't really address or reconcern after something has happened, but more so stop or prevent something before it starts.
Excellent presentation, thank you. Now, you're proposing that there is insufficient regulation by the US government. And as you know, under the Space Treaty, Outer Space Treaty, we actually have an obligation to regulate. I can tell you that industry is not so thrilled with the thought of being more regulated. In fact, we underwent a very significant effort to change, for example, the licensing processes for commercial remote sensing. Have you thought about how to make, what you can do to make the prospect of being regulated more attractive to US industry?
That is a great question. I think the biggest thing is understanding. I think majority of the private sectors look at what they're gaining now rather than later. And the idea that based on the conversations that I've had with several people, it weighs more to put it off and say it could be someone else's problem later on. I only want the reward now. But determining regulation, I feel like in place of futuristic aspects and what you can gain from it. So kind of like giving you the blueprint up front of what we're trying to do, I think promotes someone to gain interest more on what they can achieve as they build up wealth going towards the future rather than what they can achieve now. The unknowns of space are still unknown. And the idea that a private company thinks that they're in a place where they could gain their most amount of wealth at this point, I feel like it's insufficient to the amount of wealth you can gain later on through the use of regulations, ensuring that space is an active domain, safe for you and everyone else. Thank you.
Ruben, could you just speak for a moment? Obviously, you're a member of this project team. Where do you see your team's research going as you continue to work on this project? And what would be your team's ultimate goal?
So as of right now, the team is deciding to put together a publication, so one big paper. Within this one big paper, it overviews the idea of what exactly this United Space Nations is, and it breaks through majority of these 5 main pillars. Now, from this research paper, everyone that is a part of the team will then take a piece and break it down into their own research paper, expounding more on the policy in which they created in the original paper. So kind of like I spoke about Cadet Baranian's idea of the FAA for space, implementing that into his own research paper and explaining why it would be important to his career field.
Some of your argument was predicated upon the need for allowing treaties to allow certain actions. My understanding is that international law generally tends to disallow actions, and actions that aren't allowed or aren't disallowed are allowed, therefore. So do you think that this at all affects or might bring down the rate at which you're proposing this institutional creation and policy advancement?
Great question. And that's something to think about, the idea of treaties. But again, look at the time the last treaty was created. And also look at the idea that we're fighting in a new domain, which we rarely know anything about. So litigation itself, I think treaties were created kind of the idea based on the common law of knowledge that we had. However, there is no common law of knowledge in space. We're still trying to figure out this idea of necessarily what works and what doesn't work. So I feel like flipping the script sometimes kind of works in this situation, again, to kind of prevent a conflict, necessarily then responding to one, if that kind of makes sense.
Sorry about that, Ruben. Didn't mean to almost cut you off, but thank you very much. Very interesting subject and very well presented. Very much appreciate it. Thanks for taking the time out for us.
Thank you, sir.
Absolutely. Okay, for our next presentation, we have Cadet First Class Kyle Samuels. Kyle is an economics major and also a member of the Precision Flying Team. As such, when he leaves the academy, he's going to go to flight training, but he's also been accepted for a position at the Harvard Kennedy School. So please join me in welcoming Cadet First Class Kyle Samuels.
Afternoon, everybody. I'm Kyle Samuels, and I'm presenting addressing Kessler Syndrome from the Tragedy of the Commons perspective. Introduction. I currently serve as the Cadet Squadron Commander of Cadet Squadron 1. I compete on the Precision Flying Team, and the next step for me is the Euro-NATO Joint Jet Pilot Training Program. So problem statement. So heavy use of outer space may lead to the Kessler Syndrome occurring, which would prevent the safe use of space for years. And what I want to answer is what international public policy solutions may incentivize a more sustainable use of outer space. And we're going to be addressing this problem from economic perspective, including the tragedy of the commons, the free rider problem, property rights, and incentives. So the Kessler Syndrome, what is it? The Kessler Syndrome occurs when space debris creates an exponential effect as a satellite collides with another satellite, or space debris collides with another satellite, which creates a cascade in which more and more objects are created, preventing the safe use of space. Outer space may become unusable for years, which would jeopardize the global utilization of outer space as a resource. And as we have more frequent and more advanced use of space with countries other than just the United States and the Soviet Union and China entering space, this is more likely to occur. So the national defense implication. So why do we care about this? Kessler Syndrome would cripple national defense infrastructure, including GPS systems, weather systems, and communication systems. Our airplanes can't navigate, our ships can't avoid weather, and our ground units can't communicate with each other. It would also create economic chaos. As online transactions become impossible, international trade grinds to a halt, and uncertainty creates vast distortions in markets around the world. So it poses an acute threat to national security, both in the United States and globally. So space is a common good. So outer space is largely a public good because it's non-excludable and non-rival for the most part, because nobody can prevent another person from launching objects into space, and because one person's use of space for the most part doesn't interfere with another person's use. This changes as we get into closer orbits, because it's still largely non-excludable. We can do little to prevent, say, North Korea from launching objects into space, but it does become rival in consumption because one person's use of space is going to interfere with another person's, as it poses a greater risk of collision. So it's important to compare this to something like a toll road. So a road is usually a public good because it's non-excludable. I can't prevent you from entering the road, and it's non-rival. If you're on the road far away from me, it doesn't impact my ability to benefit from the road. But as we've got congestion, my use of the road does hurt your use of the road because I slow you down and create a greater probability of running into you. And with the toll road, we can increase or we could create an exclusion through the toll. And so what I'm suggesting is doing something similar for space. So what is the tragedy of the commons? It's an economic breakdown that occurs with common goods, goods that are non-excludable yet rival in consumption. So the classic example is a lake with a limited number of fish and lots of fishermen who all want the fish. If we don't have property rights or a way to exclude its use, what's going to happen is all the fishermen are going to take as many fish as they can, leading to an exhaustion of the resource. Something similar is likely to happen with outer space and our close orbits. Each country or company faces the full incentive to launch more satellites, but only incurs part of the cost. And what that cost is the increased chance of collision or the Kessler Syndrome occurring. And the core issue is that nobody owns outer space. We don't have an ability to exclude. So potential public policy solutions. So my goal is to think of different ways that we could fix this problem. So just as the previous presenter alluded to, an international space governing body could impose a tax on space launch that could force entities that launch things into space to internalize the external costs they impose on others in the form of the greater risk of collision. So obviously, it'd be very challenging to force all countries to join this. If there are bad actors like China and Russia who don't want to join it or are going to cheat the system, then we're still going to have a problem. A second option is to assign property rights to specific orbits. This would require altering Article 2 of the Outer Space Treaty, which essentially states that countries can't claim sovereignty over areas of space. But if we assign property rights, just like we assign property rights with the lake to avoid overfishing, it would incentivize actors to only launch into space to the extent that there aren't collisions, instead of imposing the cost on others of the increased probability of the Kessler Syndrome. A third option is extending the licensing scheme for awarding temporary orbits that the International Telecommunications Union currently has for geosynchronous orbits. So if another way to create an exclusion through awarding property rights would also create a reduced probability of the Kessler Syndrome occurring. So an important thing to note here is that right now we're trying to subsidize more space exploration because it creates a positive externality for society in the form of more technology. But as the negative externality of more congestion increases, at some point the negative externality is going to outweigh the positive externality. And that's the point at which we're going to want to implement some of these. And obviously there's no way to tell exactly when that occurs, but we're definitely approaching that side of things. So another problem is the free rider problem that occurs with cleaning space debris. So cleaning space debris creates a public good. It's non-excludable and it's non-rival in consumption. Just like national defense. Once we provide national defense for a country, we can't exclude anybody from benefiting from it, and my benefit from it does not reduce your benefit from it. So that means that a country which devotes resources to cleaning outer space incurs the full cost, but only a fraction of the benefit of cleaning outer space. And this leads to something in economics called the free rider problem, which involves under-provision by the private market. So public policy solutions to this free rider problem. So with national defense, we fix this free rider problem by taxing everybody. By taxing everybody, we're able to gain enough funds to provide the full public benefit that no private individual could possibly provide. So the first solution with space would be to tax all users of space to prevent free riders and under-provision. So we could tax each user of space in proportion to the amount of debris they create in order to provide the public benefit, the public good of cleaning space. The second solution could be to require countries to post collateral to ensure against debris creation. So by posting collateral, there's a fund from which the International Space Governing Body could pull if there's debris creation. And these would incentivize higher safety standards for space. So overall, space is a relatively new domain, especially for commercial entities and for non-superpower countries. And as we enter this new market, space is going to be subject to the same market breakdowns that all markets are subject to. And it's vital that we implement sound public policy in order to increase our sustainable use of space and maximize our benefit from this good. Any questions?
Kyle, thank you so much. We heard a little bit at yesterday's space debris panel about possible ways to mitigate the harmful effects of space debris. One of the problems, of course, that was addressed at that panel was the problem of other countries, potential US competitors, for example, owning particular space systems that are now defunct, or even space debris particles or pieces of those former systems, who may object to the removal of those things from orbit. What are your thoughts on that? And do you have any ideas about how those things could be addressed?
Yes, sir, that's a great question. So to me, you're talking about two different costs and benefits. One country's benefit to keeping a satellite in orbit, and another country's benefit of removing it in order to put something else there or to prevent damage to another object. And economics tells us that we should do the one that has the greatest amount of benefits compared to its costs. So an international governing body for space could potentially create a barter system in which the country that gains to benefit from removing that object could pay the country that doesn't want it to be removed. And if there's an amount of money at which the country that doesn't want to remove it would take rather than keeping it, and an amount of money that the country that wants to remove it is willing to pay, we've got room for negotiation in which both parties benefit.
Question for you. Really enjoyed the infusion of economic ideas into the solution set. One question that comes up in these types of discussions are that your scheme might violate, or not violate, but might favor more advanced, economically wealthy countries for the current use of space, as opposed to benefiting developing countries in their future use of space. Are there other analogies in other areas that you've studied where that problem has been addressed that could be carried over to the use of outer space, or has your team, or have you thought about this particular question?
Yes, sir, that's a great question. I honestly haven't thought much about how to address it because obviously if a satellite is benefiting 300 million wealthy people in the United States versus a couple of million people in poverty in another country, the whatever international space governing body is going to be more likely to favor the one with more people and more wealth. I think the best way to solve that would be for the wealthier country to help subsidize space use for the less developed countries in order to have safer satellites that are less likely to create more debris or to assist in the debris cleanup for those countries.
Thanks for your remarks. The space debris problem, orbital debris, is one of the real conundrums that makes operations in the domain challenging. So I'm grateful to see some thoughtful work going into tackling it. My question is, which of the different types of debris clearance technologies have you looked at? And do you think that any of them have particular promise in terms of addressing issues of responsible behavior in outer space that can be had? For example, one of your slides had the artist depiction of an object grabbed by a net. I know other folks have talked about directed energy solutions to knock smaller pieces into Earth orbit to burn up in the atmosphere. There's been systems servicing satellites, and obviously the space shuttle that had grappling hooks for servicing things, and those each raise more or less different issues. Have you looked at the different technology solutions and how they might raise promise or challenges with respect to responsible behavior?
Yes, sir, I have a little bit. So anything that could grab a defunct satellite and take it raises issues of property rights and intellectual property and secrets that countries may want to keep. So that's one potential issue with that solution, is that countries may have an incentive to blow up their own satellite in order to prevent secrets from getting out, which would obviously create a lot more space debris. I imagine something like that knocks it out of orbit may be cheaper. But either way, cleaning space debris is going to lead to the free rider problem, because the country that does it is going to face a huge cost that everybody else is going to benefit from. So we're going to have an under provision. Excellent
presentation. So one of the issues that I thought about with the space debris problem is the issue of the sovereignty of the property rights of a sovereign. Certainly in the law maritime domain, which I practiced for quite a few years, a maritime vessel, a warship of a nation, even on the bottom of the ocean, never loses the sovereign country never loses the property rights to that. That hasn't, I think, been completely translated to space, but it would not surprise me if countries would say, wait a minute, that's my sovereign property and you may not touch it. And so have you thought about the model for how do you deal with, number one, identifying who's the sovereign? Because for some of the space debris, that may be a difficulty and might be easier because if you can't identify it, then it's a free-for-all. But secondly, overcoming that question of ownership of the debris.
Yes, ma'am, that's a great question. And I think a big differentiator might be if there's a satellite that's entirely intact, for example, or a ship that's entirely intact versus one that's been split into millions of debris. At what point is it really no longer owned by that person or that company? So if a tiny piece of a ship that's been blown up into a million pieces washes up on your shore, I don't think anybody's gonna have a problem with you cleaning it up. And the same with, oh really, okay. But I suppose if it's already been blown into debris, there's probably less secrets that a country can gather from it. So either way, it would possibly create a lot of issues in which one country has an incentive to keep it in orbit or to let it dissipate, and another country has an incentive to either get it out of the way of its own orbit or to steal the technology.
Sorry, one more question. Returning to the economics of orbital debris, I was wondering if in your analysis you've looked at all or thought about the possibility of essentially recycling on orbit and then using those materials for additional operations, building in space, similar to what CISLunar is investigating right now for really recycling materials and using that for going forward. Does that factor into the analysis, and does it change it at all for how you look at the cost or the benefit of orbital debris?
That's a great question, ma'am. Honestly, I haven't thought about it much, but I suppose that one would matter a lot more if we're talking about future orbits around other bodies that aren't Earth, because their resources would be a lot more scarce and there would be a greater incentive to capture orbital debris. But certainly, maybe whatever international space governing body could compensate the country whose debris has been taken and by whatever value they've captured and then contributed to whatever it's going towards.
Thank you very much, Kyle. Please join me in a general round of applause. Please accept this token of our appreciation. Very interesting discussion. Okay, we have one cadet presentation left. Cadet Third Class Walker Brunner. Cadet Brunner is from Naples, Florida. He is a legal studies major and a philosophy minor. So please join me in welcoming Cadet Third Class Walker Brunner.
Good afternoon, everyone. Thank you very much for coming to my presentation today. The theme of today's conference and this conference is responsible behavior in outer space. My research question seeks to answer the question, or my research presentation seeks to answer the question of what do we do when states not only act irresponsibly, but when they act aggressively? Is there a legal right under current international law to respond with defensive force? This might seem obvious, of course they can, but actually the question is a little bit more difficult than it may appear because of some of the specific space-related international law on the topic. So to get us started, we need to start with some of the UN Charter articles, specifically Article 2, Paragraph 4, and Article 51. Article 2 specifically creates a general prohibition against, quote, the threat or use of force against the territorial integrity or political independence of a state. Article 51 creates an exception to this by saying that every state has an inherent right of individual or collective self-defense if an armed attack occurs. Now, Article 2, Paragraph 4 does not explicitly define what is meant by a use of force, but generally it means, or is held to mean, a conventional military attack, be it with some kind of military weapon. Nicaragua is an ICJ case that helps to determine what an armed attack means, because Article 2, Paragraph 4 creates a prohibition on the use of force. Article 51 says you can break that prohibition if an armed attack occurs. So the two are not the same. Nicaragua created kind of a framework for evaluating what these terms mean. So essentially, an armed attack is a use of force that rises to a certain level of severity. So every armed attack is a use of force, but not every use of force is an armed attack. This presentation will only seek to establish what a use of force is. We will not seek to use Nicaragua's scale and effects framework for establishing when the severity of a use of force rises to the level that would warrant a defensive response. So in essence, I'm just trying to lay the groundwork for when a state, a victim state to a space attack, can use defensive force in response. Let's explore this idea of use of force a little bit more. In the quote I read, there were two separate disjunctive elements. There was territorial integrity and political independence. Territorial integrity might seem like the common, this makes sense, common sense avenue for warranting a defensive response. But there are some aspects of Article 8 in the Outer Space Treaty of 1967 that makes this a little bit more difficult. Article 8 attaches ownership to a space object through the concept of a registration. It creates the need for an international database of registered space objects. And states are then given jurisdiction over their space objects that they have registered under Article 8 of the Outer Space Treaty. What this notably does not do, however, is attach a nationality to the space object. It only attaches ownership and jurisdictional control. And so, based on the OST, you cannot qualify a space object as national territory warranting defensive response under the territorial integrity part of Article 2. That said, this idea, also, the liability convention and rescue agreements, they similarly use concepts of launching state or launching authority. Nonetheless, they do not attach the idea of nationality to a space object either. And then finally, the Nottebohm ICJ case says that essentially, if a state doesn't register their space object, which they might not do because, well, you have to publish that you have a space object in space and also its orbital parameters, and for military, national security reasons, a state might not want to do so. So nevertheless, if there's a genuine link, this could be operation of a satellite, launching of a satellite, or creation of a satellite, then there could be this ownership, this jurisdictional control imparted to that state. But in none of these cases is the idea of nationality created. So we have to look toward political independence. Can this idea created under Article 8 of the Outer Space Treaty, can that create this concept of a defensive response using this quasi-territorial jurisdiction that is granted to objects that are owned by the state? To do so, we need to explore more the concept of jurisdiction in international law. As Oliver Wendell Holmes noted, the application of law to the acts of men is jurisdiction, and by extension, the acts of states. There's three main ways in which international law tends to view jurisdiction. There's three elements. First is prescription, the creation of law. Second, the adjudication. And third, the enforcement of law. These all apply to the space domain. The most important factor is the enforcement. It is foreseeable that a space attack against an object in space would infringe upon the ability for the victim state to maintain compliance and enforce compliance upon the laws it is created for that space object. And so if a kinetic attack destroys or a cyber or electronic attack degrades the ability for control of that satellite or other space object, then therefore the victim state no longer has the ability to enforce compliance upon that space object. And so you have a violation of the jurisdictional element of enforcement. Prescription is a little bit more attenuated. I think that you could argue that if a kinetic attack entirely destroys a space object to where it ceases to be non-arbitrary, then you no longer have the ability to prescribe laws for that space object. But I think that any space attack that would qualify as an infringement upon this prescriptive jurisdictional ability would also qualify as an infringement upon the enforcement ability. So I think this lessens its importance, and generally the enforcement aspect maintains a primacy. And then finally, adjudication. This is not maybe as important right now, but as we have discussions of colonies on the moon and on Mars, I think that in the future, the coming decades, this is going to maintain and create an increased importance in the idea of adjudication and the ability for a state to adjudicate matters on celestial bodies and in the outer space void. And then we have this idea of political independence. So essentially, this was a state right that was created under the 1648 Peace of Westphalia, which established, among other things, the idea that a state has the right to sovereignty, that no higher power exists over the state, and that every state is horizontally organized, essentially. Now, this concept of state sovereignty and the according authority that's given to states, the state needs to have certain rights to be able to exercise this idea of sovereignty. One of these is territorial integrity, and another is political independence. And specifically with regard to political independence, without it, you can no longer make decisions regarding the laws, the institutions, and ultimately the values and the culture of your state. And so that's why political independence is such an important part of not only the UN Charter, but generally the idea of state sovereignty. Now, to put all of these ideas together, I kind of alluded to it earlier with the idea that political independence allows the creation of laws. I think it is clear that without the ability to have either prescription, adjudication, or enforcement, that you really lack any serious control and authority, ultimately sovereignty, over your state and the objects in your control, such as space objects. An important part to this is that without the ability to make laws, to prescribe laws, you really don't have any sovereignty, any authority, but also without the ability to enforce or to adjudicate, you really only have maybe an illusory capability to exercise your state sovereignty. And this is important because only one aspect of the jurisdictional control granted under Article 8 of the Outer Space Treaty is therefore needed to warrant a defensive response to a space attack. And then finally, Article 3 of the Outer Space Treaty specifically prescribes that the laws governing general international law do not end in the upper atmospheres. They're applied to space. This is important because while there are certain space-specific international treaties and accords, the general basis for which this argument rests are using non-specific, non-space international law. And so that's important to note that this does apply. And what we come to our conclusion by answering the question of whether states have a right under international law to exercise defensive force should they come under a space attack. And the answer ultimately is yes. Their quasi-territorial jurisdiction granted under Article 8 means that without the ability to have either prescription, enforcement, or adjudication control over their space objects. They no longer have full exercise of their state sovereignty and therefore can use defensive response. So the key points. Space objects are not technically sovereign national territory. While it might seem so, we have ownership of them, but they are not ours in the same way that a naval vessel is national sovereign territory. And then political independence, even though this idea of territory doesn't allow for defensive response, political independence provides the avenue through which a defensive response can be warranted. And then, as I mentioned, the enforcement is the most likely way through this defensive response to be warranted, though adjudication will likely have an increased role in the future. And then finally, this does not mean that a defensive response is necessarily warranted. It only means that should the idea of Article 51, the armed attack, should the severity and the scale and effects rise to the level that is needed, then you have warranting of a defensive response. Thank you all for coming to my presentation, and I look forward to your questions.
Well, Walker, thank you so much. Great presentation. Really, really appreciate it. Just a quick question. There is within international law this concept of countermeasures, things that countries can take against other countries when an international wrong has occurred that maybe doesn't rise to the level of a use of force or a threat to sovereign territory or a threat to political independence. Granted that it's a little afield of your presentation today, what do you think those sorts of countermeasures could look like in the space environment? And what sort of actions or activities kind of in this framework that you've discussed might be wrongful acts in space that don't quite rise to this level?
Yes, so one that easily comes out is espionage. So economic coercion, political coercion, espionage are three main concepts that do not rise to the use of force determination in international law as held by customary practice. And so I think what you could have an example of in space is maybe a cyber attack that regains control or is able to infiltrate a remote sensing satellite and then take the pictures and use the pictures. That would be maybe a form of espionage. It might not necessarily rise to the level of an armed attack, but that would be an example of a sub-use of force that would not necessarily presuppose a use of force determination. And that would warrant response, but not necessarily response such as military action, as the armed attack idea necessitates.
Yeah, you wowed everybody. So all questions answered. So thank you very much for that presentation. Very eloquent, very well done. Very much appreciate your time.
Thank you.
Thank you very much.